Simon, there have been a couple of recent English High Court decisions on bank guarantees in Rainy Sky and Enker.
Yes.
Before we talk about the decisions in those two cases, I just wanted to draw this distinction between surety guarantees and bank guarantees.
Yes, well, a surety guarantee is an arrangement by which one party agrees to perform the obligations of another.
And a bank guarantee?
And a bank guarantee is a very different legal creature. And bank guarantees really cover a range of different sorts of instruments. They range from advance payment guarantees to performance bonds to refund bonds to refund guarantees. So it's quite a generic expression.
Okay, well, what are the characteristics then of a bank guarantee?
Well, I suppose the characteristics are threefold. The first is that it's independent of the underlying contract, wholly. Second, it's autonomous. That is, the claimant really only needs to look at the four corners of the bank guarantee itself. And third, it is documentary based. So the bank's liability is triggered not by a breach of the underlying contract, because as we said before, it's autonomous, but upon the presentation by the claimant of a demand that conforms to the form of demand required by the bank guarantee itself.
So in assessing whether there is a claim or not, the bank doesn't have to take any further steps other than look at the paperwork it receives?
Exactly, and some of the judges in previous cases have said they've used the expression that the bank doesn't need to act as a detective. It's not concerned to investigate whether or not there has been a breach. All it needs to investigate is the accuracy and conformity of the demand itself, as you said.
Okay, well, thanks for that. Turning now back to Rainy Sky and to Enker, in both of those cases, the banks who'd issued guarantees were looking to avoid their liability by looking beyond the form of demand itself and looking through to the alleged breach of the underlying contract.
Exactly. In both cases, to a greater or lesser extent, the banks were saying, well, the notice of demand that you served upon us didn't specify accurately enough the nature of the underlying breach, because, again, to a greater or lesser extent, both bank guarantees required that there be reference made to the underlying breach.
Were the banks successful in that argument?
Well, the banks weren't successful because, coming back to the points we mentioned before, the judge in both cases emphasised once again the independent and autonomous and documentary-based nature of the obligation. So by saying that, he was trying to emphasise that there is a limit to the extent that you need to investigate the breach, and you've gone beyond what you're required to do because you received a demand that conformed, therefore you really should pay.
And so a bank issuing a guarantee needs to take a specific contractual indemnity to protect itself.
Once the bank guarantee has been issued, in the absence of fraud, that is the equivalent to cash. And the judges have said in previous cases that really bank guarantees could be categorised more as promissory notes than guarantees. So for that reason, the bank does need to get a specific counter indemnity from its customer, because, again, another difference to a surety guarantee is that in a surety guarantee, that indemnity would be implied as a matter of law. So a guarantor that made a payment under a guarantee is entitled to an indemnity from the principal debtor. That doesn't happen with bank guarantees.
Okay, and finally, would banks expect to take other forms of credit support as well?
Yes, depending, I suppose, on the creditworthiness of the customer or other person at whose request the guarantee's been given. It might, for example, consider taking cash collateral. For example, that's already in the Loan Market Association suite of documents for their facility agreements. Or they might even require security in certain situations.
Thank you, Simon.
Thanks very much, Richard.